So this goes out next. So there's usually quite a lot of work that's gone on in the lead up to this. By the time this letter arrives on people's doorstep, it's not entirely unexpected in most cases. Although in my experience, that doesn't stop them sitting on it for quite a long time, and perhaps they're taking a long time to read it and distill it. I don't know. The difficulty with sitting on it and waiting to take action is that in the Cambridge area in particular, there's a requirement to lodge your own case 14 days before the hearing. And by the time you've come in and taken advice and been given what is normally a surprisingly long list of stuff you need to do, you also need time to do it. And so the closer you are to the hearing, the less value you get for money if you come and see us. The sooner you come, the sooner you take the advice, the more opportunity you have to implement it, and hopefully the better the outcome. So there are a number of legal requirements in place in respect of sending these out, and over the years they've been amended on a number of occasions to make them more easier to read. They've been translated, or attempts have been made to translate them into plain English. I don't think everyone reads them still, but there are, of course, a number of criteria that have to be covered. They give you a list of why you're there, they give you a list of what you've got to produce, and when by. So, in our case, Mr. Albescu has received a letter. He's required to attend a hearing in respect of a desk-based assessment he participated in some months before.
So here we are making my point. Look at this, it's seamless. And the two of us, we spoke about this once, I think. It is just brilliant, I can tell you. But look, this is the time when the operator, the party, should have been thinking about preparing for public inquiry, should have been thinking, do I need to get representation involved? What's my plan for dealing with the shortcomings that have been identified by DVSA? I think quite a few operators think, well, they've given the chat to the nice examiner, or the person that's written to them. They've written a nice letter. Oh, well, that's the end of it. I can forget about it. And that's often the impression that I'm left with. They've done nothing. Carolyn and I have regular meetings where I'm looking at her over the top of my glasses. I'm sat slightly higher than her with a crest behind me, probably thinking the same thing. Why did they leave it so late? You know, a DBA, an MIVR, traffic examiner visit report is likely to be completed around about 5 to 6 months before the hearing. All that time to start getting things right, all that time to start demonstrating that things have changed if there were shortcomings identified, and yet here we are, unfortunately, at public inquiry. The call-up letter's gone out, 5 weeks notice, and still 5 weeks later they haven't done anything. Hopefully, they might get around to talking to Carolyn, one of her colleagues, slightly more than 14 weeks before the date of the hearing. Unfortunately, more likely than not, it isn't. And yet, here's all the evidence. So when that came to me in electronic format, in electronic submission, I'm going, how did you allow poor annual test? How did you allow your maintenance to deteriorate to have a poor annual test history? Bearing in mind you're scoring negatively on one vehicle once every 12 months, that's been happening some time, hasn't it? Who's been monitoring it? Then I begin to wonder about the maintenance and pre-annual test. Oh, it's not like we've heard anything about brakes this morning. It's not like traffic commissioners have been banging on about this particular issue for over 8 years since the tragedy involving Grittenham Haulage in Bath. I don't know how much longer we can go on, but because it is in every annual report. It's in regular pings from the Office of the Traffic Commissioner. So you can understand why I'm a bit concerned about that. Again, Patrick, what was he saying about driver detectable defects? What does it say if I've got driver detectable defects appearing at the inspections? So this is the type of information. And what is that all telling me? Well, it's drawing into contrast what type of management. And if I'm asking about management, then I'm going to ask about how can I trust this operator to ensure future compliance? And we're going to come back to that question because it is absolutely key to the public inquiry. I think it's back to you, isn't it? It is, it's just like unrehearsed.
So we arrive at the hearing, me and my operator. And what usually happens is I give a list of A to E, and they send A, F, and G. I'm asking where's B, C, D, E, and they don't turn up. And partly I think it isn't available, partly I think it's too difficult, and partly I think they're rather hoping that what I've told them just actually is wrong, is overkill, or my predictions are inaccurate. And sometimes it takes for them to go before Mr. Turfitt and for him to tell them what I told them 2 weeks ago, for it finally to sink in. But for some, of course, by then it's a little bit too late. So our operator in the case study is doing mostly third-party traction. So he's working for a large, well-known parcel delivery company. And he is doing mostly third-party traction. When he turns up, of course, he says, well, I obviously haven't got any of their records, but that's nothing to do with me, because that's their responsibility. I'm looking after the vehicles. I'm just picking up those trailers. They have a transport manager who obtained his qualification in 2016. In 2016, he was living in the UK. But he went back to Romania, in our example, on holiday. Whilst he was on holiday, he picked up the qualification. And so queries are asked around that, and this is coming up all the time. He'd been out of the country for 5 months when most of this happened, and said, well, I was only out of the country for 5 months. I left them with a to-do list. They've got a disciplinary policy, but nobody ever uses it. And all of the roller brake testing is unladen. So these are the potential issues that we are facing this morning at our public inquiry.
So, full of the joys of spring. If we can move on to the next slide. I do bound into the hearing. Well, actually, it's more like a shuffle these days because I'm getting on a bit But before I come in, my staff and I have sometimes 14 days, sometimes it's on the day of the hearing, being provided with a large cardboard box or a plastic crate full of original maintenance documents. At which point we divvy them up. I do a quick dip sample. My staff do as well to make sure that I'm not way off. And my staff are fantastic at doing this. They really are tip top. And I have a dip sample. I look at the inspection records. I start looking for driver detectable defects because I know that's the examiners have already kindly identified that for me. I start looking at brake test results. I'm looking at tyre pressures. Sometimes I'm looking for them for a very long time because they're not on there. I'm looking for signatures of rectification work. I'm looking for the declaration of roadworthiness to say that the thing, and I'm doing this all in a very short period of time. Bearing in mind that the operator has been on notice of these concerns since the desk-based assessment, anything that I observe shouldn't be a surprise to them. So I suppose the message from us, all of us, this side of the table, is if there's an investigation, think about how you're going to address it and get on with it. If there's a risk of a public inquiry, get on with it. Prep. Don't just till the last few minutes, I would have gone and got you some financial evidence, but the bank wouldn't stamp it for us. When did you try? Yesterday. Oh, well, it's given me the right impression about your preparation for this public inquiry, isn't it? I don't want to revoke operators, but I will do so if I think there's a whiff of undercutting other operators or road safety. I'm going round in circles. There are times when I go, I'm being promised the earth. They've promised me everything. They've just started. You can see a little glimmer. There's a brake test, and they've done it properly, and you're crying because if only they'd done this before. But there's a little glimmer of hope. There's a new transport manager that's, new to you, and there's a new Transport Manager 1 form that's newly arrived, beautifully minted, smelling fresh. And you think, maybe, just maybe. The problem is, they've had all these opportunities. They've had previous visits from DVSA. They've had warning letters. They've been at public inquiry before. It cannot go on as it is. And you need to make that clear to them. I will set a revocation date sometimes in the future and say to them, if in that intervening period you can get yourself right, I'll look at that on your new application. But if you don't, you have to go. You have to go from the industry. That's another consideration. I suppose what I'm trying to say to you is, it's a darn sight more complicated than reading a snippet in news or court reports, or even just taking a snippet from the OTC's circulations. And every case is looked at on its individual merits. So, there are heartbreaking stories I get, and I still have to revoke, about people's houses that are on the line for the business, people who've, family history back to 1940s. All of that gets weighed in, but there are times when you still have to say, I'm going to put an end to it, but there's hope. Patrick said about suspensions, you might as well revoke. Oh, no. There's a really good upper tribunal case which says, okay, suspension, yeah. It's not revocation. It might feel like it for that period, but there's still a glimmer of hope about coming back. And we haven't even touched on the question of disqualification. So, just one warning for all you transport managers and goods transport managers. The law has changed. As of the change in March, now if I disqualify somebody from utilising their goods CPC, minimum 12-month disqual. So, sorry to end on a bummer. Do you want to pull it back, Carolyn? Say something else.
For those of you who participated in the VVOX question, how many of you thought the licence was curtailed for quick skip? Show of hands. How many thought it was suspended? And how many thought it was revoked? Well, you're right, actually. It was suspended for 2 weeks, and the transport manager lost his repute and was disqualified.
Without access to finance, without access to a transport manager, please ask for a period of grace. I can grant that for you up to 6 months normally. If your transport manager sadly died, I can give you up to 9 months. I won't be giving you automatically 6 months, because that's a cliff edge. So what I tend to do is grant it in blocks, and you show me that you've taken steps to try and recruit. But it's there, it's your facility. So if we can try and get that message out as well. And my last point, look, I hope we've demonstrated over the last couple of years that we are listening and we are flexible. That doesn't mean you get out of jail card, you don't. But we will respond, we will try and react. I'm not going to turn a blind eye, though. There was forgive me for mentioning, but a policy manager from a trade body departed with a little shot saying, oh, well, you know, traffic commissioners, they should all be transport managers. No. My decisions are based on the evidence that I have. And if I don't take a decision based on the evidence I have before me, the upper tribunal overturns me. So I don't quite know what the point was being made. We consult on policy changes, even to the point where the emergency stuff I put out just before the lockdown, I rang round the chief executives of the trade bodies that I could get hold of, and I talked it through with them.
Thank you very much, and thank you to Richard Turfitt for taking time out of his very busy schedule today to talk to us. Very much appreciated. Just before we close the session, I know everyone's starving, Caroline Hicks from the DVSA has just got a quick update in respect to the attestation forms hot off the press. So stay where you are, stay where you are.
Right, I did tell you they were looking at it. Excuse me, I will read it so that I don't get anything wrong, but I will send the detail through to Carolyn. I've sent her the other two documents that I mentioned, so I will send this through as well. So, first of all, think of your fixed week, so 0000 Monday through to the 2400 on the Sunday. If there is no driving in the fixed week, it has to be the fixed week, not a week. You can record it all on block, so a single record that has the driver's detail can just be recorded as other work, leave, whatever it was. You can do it all in block, a single record. That can be on an analogue record sheet, on a printout taken from the smart tachograph. But you record the start and the finish time of the fixed week. The driver's details have to be recorded on the back if it's a digital printout, but in the usual place if it's on an analogue. If you use attestation letters, you do still have to use attestation letters all the way through. If there is driving in that fixed week, then on the days where there isn't, it can be recorded on an analogue record sheet with the driver's name written in the usual place and just on block on that, or on the printout with the driver's details on the back. But if there is no driving, it can just be a single record. But if you use the attestations, you have to use one for each of the activities, as we talked about earlier. So I will send the details through so Carolyn can send them out, but that is literally hot off the press for you.
Very useful. So that's it for today. Thank you ever so much for coming. I hope you enjoyed it. It's been a busy session.